In Chapter 20, we look at corporations in more detail. Last chapter, Chapter 19, we looked at the different types of business organizations. Generally, the corporation is a creature of statute. It's an artificial person. It can have one or more shareholders. They can be natural persons or other businesses. Corporation substitutes itself for the shareholders and can access the court system, and it has constitutional guarantees of free speech, due process, and things like freedom from unreasonable search and seizure. Corporate personnel are responsible for the overall management of the company. That rests with specifically the board of directors, who are elected by the shareholders. They make policy decisions and hire officers to run the corporation on a daily basis. The shareholders could sue a corporation and be sued by the corporation and bring suit for corporation in some instances. Shareholders by nature have limited liability. That's one of the key advantages. In certain situations, however, the corporate veil of limited liability can be pierced, holding the shareholder personally liable. Corporate profits can either be kept as retained earnings or passed on to the shareholders as dividends. Corporate taxes can be taxed twice. First, the corporation is taxed, and then dividends that are distributed to the shareholders are also taxed. Holding companies are companies whose business activity consists of holding shares in another company, and typically a holding company is established offshore. Corporation is liable for the torts committed by its agents or officers under the doctrine of respondeat superior. They can also be liable for criminal acts, but only fined. It's difficult to actually put a corporation in jail. However, the responsible officers may end up being imprisoned. There are different types of corporations. A domestic corporation does business within the state of its incorporation. Foreign is a little different. It means a corporation from state X doing business in state Z. An alien corporation would be a corporation outside the United States. There's also public and private corporations and even non-profit corporations. A closed corporation is a corporation that has few shareholders. It's informal management like a partnership. There are restrictions on transfer of the sale and transfer of shares so that it remains closely held. There are management issues such as the transfer of shares, shareholder agreement to restrict the stock that can be issued, and potentially the misappropriation of funds. An S Corp is an entity that's used to avoid federal taxes. It's called a subchapter S. It avoids double taxation. Only the dividends are taxed to the shareholders as personal income. The IRS requires that the corporation be domestic, have fewer than 75 shareholders, and only one class of stock, and no shareholder can be a non-resident alien. Process of incorporation usually includes the preliminary and promotional activities as well as the legal process of incorporation. We talk about promotional activities. The promoter is the person who's doing these activities may have personal liability for pre-incorporation contracts on behalf of the corporation unless the third party that they're dealing with, contracting with, agrees to hold a future corporation liable. In terms of incorporation procedures, you're selecting the state of incorporation, securing a corporate name, preparing the articles of incorporation, which typically deal with shares, registered agent, officers, incorporators, the duration and purpose of the corporation, and its internal organization, and those articles are filed with the state of incorporation. Then there's the first organizational meeting. The purpose of the meeting is to adopt bylaws. After the corporation is chartered or created, it can do business. At that meeting, the shareholders should approve the bylaws, elect directors, hire officers, and ratify pre-incorporated contracts and activities that we were talking about. Issues can arise when there's improper incorporation. A de jure corporation means it substantially meets the statutory requirements. So even though it doesn't actually go through the process of meeting all the requirements, it can't be attacked by the state or third parties. De facto means they're not met, but the promoters made a good faith effort to comply with corporate law, and in that case it can only be attacked by the state. Or there's corporation by estoppel. If an entity holds itself out as a corporation to third parties, it cannot avoid subsequent liability by claiming that no corporation exists. In other words, it's stopped or prevented from getting out of a contract, for example, because it led the third party to believe it was a corporation. Corporate powers are found in the corporation's article of incorporation, the laws of the state of incorporation, and in state and federal corporations. The corporate bylaws may also grant or limit a corporation's express powers. Earlier we were talking about piercing the corporate veil or imposing personal liability. This is what the court might do and hold the shareholders personally liable if it's in the interest of justice and fairness. Factors the court looks at include a third party tricked into dealing with a corporation rather than the individual. A corporation is set up never to make a profit or remain insolvent or is thinly capitalized. The statutory formalities aren't met, or there's a commingling of personal, corporate interest or assets. In other words, perhaps the corporation represents itself to be a corporation but doesn't actually follow the statutory or accounting processes that are required. There are different ways to finance a corporation. One is bonds. These are issued by business firms and government at all levels. Normally these bonds have a maturity date, which is when the principal is returned to the investor. Sometimes they're referred to as fixed income securities because the bondholder receives a fixed dollar interest payment. There's also bond indentures. Another way of financing corporations through stocks. There's common and preferred stocks. Common stocks represent the true ownership of corporation. They provide a pro rata or proportional ownership interest reflected in voting, control, earnings, and assets. Shareholders typically receive dividends as declared by the board of directors. A preferred stock, as the name implies, have preference over common stock, and there are different classes of preferred stock. Other ways of financing a corporation could include venture capital. Startup businesses and high-risk enterprises need startup capital, expansion capital, and typically the startup would give shares of stock. There's also private equity capital. This is usually wealthy investors. Ultimately, a company may sell shares in their initial public offering or IPO. Directors of a corporation. The corporation is governed by the board of directors elected by the shareholders. Individual directors aren't agents, but the board is a super agent and is capable of binding the corporation. A director could also be a shareholder, especially in a closely held corporation. Directors in a closely held corporation are generally the incorporator or shareholders. The number of directors is set forth in the Articles of Incorporation, and they're, as we said earlier, they're appointed at the first organizational meeting, and usually that's for a period of 1 year. They can be removed for cause. They're often compensated. There are inside directors or officers versus outside directors. Once the same person is both an officer and a director, often the same person is an officer and a director and receives compensation as the officer. Board of directors meetings, you need a quorum to conduct official business. Directors have a right to participate in corporate decisions, inspect corporate books, records, and compensation. The corporation should guarantee reimbursement, indemnification for liability, protect them from personal liability. Directors and officers are fiduciaries. They owe the company an ethical and legal duty. They also owe a duty to make informed and reasonable decisions. Directors are expected to be fully informed on corporate matters. They have several duties of care: a duty to exercise reasonable supervision, a duty to make informed and reasonable decisions, and a duty to exercise a reasonable decision. That looks like a repeat there. Business judgment rule immunizes a director or officer from liability from bad decisions. The court will not require a director or officer to manage in hindsight. In other words, in hindsight, if it was a bad decision, the court really looks at the reasonableness of the decision at the time based on the information that's available, and if the director or officer acted in good faith and in the best interest of the corporation. Corporate officers serve at the pleasure of the board of directors, but have a fiduciary duty to the company as well. Their employment relationships are generally governed by contract law and employment law, and they can be terminated for cause. Here's some detail on the director's duty of loyalty. They're not supposed to serve their personal interests over the welfare of the corporation. They're not supposed to compete with the corporation. They're not supposed to have conflicts of interest, participate in insider trading, etc. They have a duty to disclose conflicts of interest, as we said earlier. That means full disclosure of any potential conflict of interest and abstaining from voting on any transaction that may benefit them personally. If the transaction was fair and reasonable, it could be approved by a majority of the disinterested directors. Officers and directors may be liable for crimes and torts committed individually and or those committed by their employees that are under their supervision. The shareholders could bring a derivative action or derivative suit where they sue the directors on behalf of the corporation. Shareholders have an equitable ownership interest in the corporation, but generally have no right to manage the daily affairs of the corporation. They do it indirectly through electing directors. The controlling shareholders owe a fiduciary duty to the minority shareholders. Some powers of the shareholders: approving all fundamental changes, amending articles of corporations or bylaws, approving mergers, acquisitions, sale of corporate assets, dissolution of the corporation. They can also elect and remove the board of directors. Shareholder meetings need to occur annually. They need to publish a notice of the meeting, make sure proxies are in order, including electronic, and share shareholder proposals. A quorum is required. Shareholders represent more than 50% of the sales and shares must be present to conduct business. There needs to be a record of stock ownership, and there are different voting techniques. The rights of the shareholder depend on the articles and bylaws. Some of them are listed there, in terms of transferring shares, dividends, their rights of dissolution, the ability to bring derivative lawsuits. Shareholders can sue a third party on behalf of the corporation, or earlier we were talking about how they would potentially sue the officer or directors of the corporation. The suit isn't an individual lawsuit, it's on behalf of the company, and a written demand must be made. Shareholders are generally not liable for the contracts or torts of the corporation. If the corporation fails, the shareholders generally cannot lose more than their investment. as we mentioned earlier, majority shareholders have duties. If they own enough shares to exercise de facto or actual control of the corporation, they owe a fiduciary duty to the corporation and to the minority shareholders and creditors when they sell their shares because of the possibility of transfer of control. A merger is a combination of two or more corporations, after which only one company remains, with all of the rights and obligation of the company that's combined. So you start with A and B. A remains, and they have B's rights and obligations. Consolidation is when two or more corporations combine and a new corporation, C, is created, and the original two or more corporations cease to exist. There also could be a share exchange. Some or all the shares of one corporation are exchanged for some or all the shares of another one. Procedures in these mergers, consolidations, or share exchanges. The board of directors of each corporation involved must approve the merger. Majority shareholders of each corporation must also approve, and then documents are filed with Secretary of State, who issues a certificate of merger. There's also short form mergers. For a parent subsidiary merger, no approval of shareholders is needed. Parent must own at least 90% of each class of stock of the subsidiary company, and the board of the parent corporation approves and new articles are filed. In terms of purchase of assets, the acquiring corporation extends its ownership and control over the physical assets of the other company. The acquiring corporate shareholders don't need to approve it, but there is the issue of successor liability. Generally, the purchasing corporation is not automatically responsible for liabilities of the selling company, but they might assume liabilities and assets if the acquiring corporation impliedly expressly assumes the liability, the sale amounts to what is really a merger consolidation, the purchaser continues the seller's business and retains the same personnel, or the sale is fraudulently executed to escape liability. A common alternative to mergers and consolidation is the purchase of a controlling interest, up to 51% of a target corporation stock. It's called a takeover, giving the purchaser corporation control or a controlling interest in that target. The responses to a tender offer, a director may view the offer as favorable or unfavorable. If favorable, then a recommendation is made to the shareholders. If unfavorable, the directors may make a self-tender to buy stock, launch a media campaign, or issue additional stock. Corporation termination could be voluntary or involuntary dissolution of the corporation. Voluntary dissolution can be initiated directly by the shareholders, or the board can initiate dissolution by submitting a proposal to the shareholders. If it's involuntary, the state can dissolve a corporation for failing to comply with state regulation. A court could dissolve the corporation if there's a deadlock or the acts of the directors are fraudulent or illegal. A court could also dissolve if the assets are being misapplied or wasted, or the shareholders are deadlocked and fail to resolve. If that happens, the corporation goes through a winding up. In the case of voluntary dissolution, the board liquidates and acts as a trustee of the assets. A court will appoint a receiver if the board refuses or creditors want a receiver. In the case of involuntary dissolution, then the court appoints a receiver. The liquidated assets go first to the creditors, then to the shareholders.